Good afternoon, everyone. My name is Dana Stansel, and I am a volunteer for the Philly SHRM Programming Committee. We want to thank you for joining today's webinar entitled 2018 Labor and Employment Law Update. During today's presentation, if you have any questions, please feel free to send them via the question box of the GoToWebinar panel, and we will read them aloud to the speaker at the end of the webinar. We also want to remind you that you are eligible to receive one HRCI credit and one SHRM Professional Development credit for attending today's webinar. You will receive a follow-up email after the webinar with a survey link that must be completed in order to receive the certificate for your credits. Once the survey has been completed, the credit forms will be emailed to you within 1 week. All slides will be sent to all attendees after the webinar. Today's webinar will feature Terry Gillespie of Jackson Lewis and Catherine Hartman of Dilworth-Paxson. Thank you both for joining us today.
Hi, good afternoon, everybody. This is Terry Gillespie from Jackson Lewis, where Catherine and I are very excited to share this time with you. And we're going to be covering a few topics this afternoon. First, in this Labor and Employment Law Update for 2018. First, we're going to give an overview of the Supreme Court's last term, the 2017-2018 term that ended in the spring, or in the summer, I guess, and also give you a preview of what to look for in the upcoming 2018-2019 term. There were a few pretty landmark Supreme Court cases in the employment context that we want to go over with you, and there are a few more that may be coming down the pike that impact your workplaces. Then we're going to give a brief update on the Me Too movement and the impact of the Me Too movement on employment law and EEOC claims and litigation, and also give some best practices tips for handling the Me Too movement now that we're a year out. And then finally, we're going to talk about medical marijuana in the workplace in light of the more recent Pennsylvania statute. So I'm going to begin with the Supreme Court Labor and Employment Update. Last term, the 2017-2018 term, as I said, was a pretty important term for employment law. There were a number of decisions that were decided that really could impact your places of business, even if they don't relate to your industry directly. And there were new cases that ranged from issues related to labor union membership fees to mandatory arbitration agreements. And we think it's very important to stay up to date on what's happening at the Supreme Court, because even if you think the case doesn't apply to your business or to your HR practice, it could have long-ranging implications for employment law. So it's important to recognize what the cases have been and how they impact your business. Okay, the first case I'm going to talk about is the Janus case. And Janus was very important in the public sector union context. Now, some of you may think this doesn't matter. I'm not a public sector employer, so it doesn't impact my business, but it does have implications for unionized workforces as well as some legal precedent issues that were raised in this case. So what happened in the Janus case? There was a state worker in Illinois, his name was Mark Janus, and he challenged a requirement that the employer, the Illinois state employer, imposed on individuals who were in a unionized work environment but chose not to join the union. And this requirement was that even if you weren't a member of the union, if you were in a position that was part of a collective bargaining agreement, you had to pay certain fees to the union for the benefits that you received in effect from the collective bargaining. And this was set in a case, it's a 40-year-old case, Abood v. Detroit Board of Education. And in Abood, public employers were allowed to require non-union workers in a unionized represented bargaining unit to pay agency fees, or otherwise known as fair share fees. to cover the cost of collective bargaining as long as the workers were not required to pay for any of the union's political or ideological activities. So you could require that employees join the union or pay the fees as long as none of their money went to any of the union's political contributions or political stances. It just went to collective bargaining because in theory, the employees were getting the benefit of the collective bargaining. So Janus overruled Abood. And in Janus, the court said that it violated an individual's right to free speech and First Amendment rights to require them to pay these fair share fees to the union, because according to the opinion from Justice Alito, all public union activities are inherently political in nature, and that if we require people to pay money towards a union that is a political body, according to Justice Alito, then that is a violation of their First Amendment rights. And the majority opinion, this was a 5-4 decision with Justice Kennedy being the swing vote, also said that neither agency fees nor any payments to a public union can be taken from an employee's paycheck unless they affirmatively consent to the deduction. So it can't be automatic. The employee has to affirmatively consent to that. So what's the bottom line with Janus? Well, now public sector employees cannot require, or public sector employers cannot require membership in a labor union if the workforce is unionized, and they can't force people to pay these fair share fees. And they can't deduct the fees directly unless they get affirmative consent from the employees. And this effect will have on the unions, it will place a larger burden on these public sector unions. So they got a lot of money from people who were not members of the union but were getting fees deducted directly from their paychecks. So now it's weakening these unions because they're not going to be getting that money. Okay, so the next case that has a major impact on employers is Epic Systems Corp v. Lewis. So this was part of a trio of cases that were brought up to the Supreme Court related to mandatory arbitration agreements. And in Epic Systems, the Supreme Court said that employers are required or are allowed to require employees to sign mandatory arbitration agreements that require individual arbitration of claims. This came out in May. It was one of the later cases decided. And essentially, the court said the NLRB had challenged this mandatory arbitration agreement requirement for individualized cases, saying that employees have the right to bring class claims and employers can't restrict those rights by requiring these mandatory arbitration agreements. And the Supreme Court rejected the NLRB's argument, the argument under the National Labor Relations Act, and it said that the Federal Arbitration Act, employers could require people to bring individualized claims and limit class arbitration. Okay, so what's the bottom line with Epic? That now we have a Supreme Court case that says mandatory arbitration agreements are allowed in contracts between employers and employees, and individuals can now be required to arbitrate their claims with their employers. So there are different schools of thought on this. Some people believe that this will limit the rights of individual employees because employers are going to be less accountable and employees won't want to file these claims on their own. This may have a big impact in the FLSA class action and collective action cases where an individual may not necessarily bring a claim for unpaid overtime or wages or things like that, but on their own, but he or she may join or opt into a collective, a group of people if somebody else brings the claim. So under Epic now, employers can say, no, you have to arbitrate all your claims, including any potential class claims. And some other people believe that this will improve employee rights because arbitration is a low-cost alternative to very expensive litigation. So we'll have to see how this shakes out going forward. Okay, the next case is Summers v. Digital Realty, and this has to do with whistleblowing activity. And essentially, under Summers, the court held that companies that are publicly traded that fall within the requirements of the Dodd-Frank Act and the Sarbanes-Oxley Act, the whistleblower provisions of those acts only apply to complaints that are made directly to the SEC and not internal complaints of waste or wrongdoing. So in order to bring a whistleblower claim under one of those statutes, an individual has to make a complaint or report bad acts to the SEC and not just internally. So the bottom line with Summers is that certain types of whistleblowing will no longer be protected or are not protected. But something to remember is that there are other statutes other than the Dodd-Frank Act and Sarbanes-Oxley SOX that have whistleblower protections. So in Pennsylvania, if you are considered a public body, if you receive money from the Commonwealth, you could be subject to the Pennsylvania whistleblower statute. If you have business in New Jersey, private employers are subject to the SEPA Act, which is the whistleblower statute in New Jersey. So there may be other protections for employees, but to gain protection under these two statutes in particular, according to the Supreme Court, the employee has to report the bad acts to the SEC directly. Okay, and next is Encino Motor Cars, LLC v. Navarro, and this is an FLSA case, and on its face, it just deals with service advisors in an automobile dealership setting. Service advisors, if you're not familiar, are individuals who are the liaison between the service area and the customer. So there was a challenge to whether or not these individuals, these service advisors, fell within the salesman exemption of the Fair Labor Standards Act. And the service advisors argued that they were not exempt and were entitled to overtime wages, but the group of automobile dealers who brought this case up to the Supreme Court said no, they are exempt because they're serving a sales function in the dealership, and they can upsell customers on certain services and, different tires, different types of equipment that people might want to purchase. So they are in effect salesmen, and they're not service techs in particular, they're service advisors. And the court ruled in favor of the automobile dealerships, the employers in this case, and said that they are they're exempt employees under the salesman exemption. And you may think, well, I'm not an automobile dealer, that doesn't really apply to me, I don't really care about this case. But what's important here is that the Ninth Circuit had based its decision to find that these service advisors were non-exempt on its finding that the overtime exceptions to the FLSA should be construed narrowly. So they wanted a narrow construction of all of the exemptions under the FLSA. But the Supreme Court said that that's not the proper interpretation of the FLSA, that they should be construed plainly. So going forward, we may see, especially with the current makeup of the court, which will tend to be more employer-friendly, we may see more cases where positions that we thought would be non-exempt, and if challenges are raised to the exemption status, that they may fall in line with exempt employees, which would be more favorable, obviously, to employers. Okay, many of you may have heard about the Masterpiece Cake Shop case out of Colorado. And in that case, an owner of a bakery refused to sell a wedding cake to a gay couple because he said it violated his religious beliefs because he did not believe in gay marriage. And the case went before, the couple brought a complaint to the Colorado Civil Rights Commission, and the Colorado Civil Rights Commission evaluated the case under the Colorado anti-discrimination law and found in favor of the couple and said that the baker had discriminated against them because of their sexual orientation. So the baker challenged this, and it brought it all the way up to the Supreme Court. That it really punted this case. It had the chance to decide whether sexual orientation and what would prevail, individuals' rights to be free from discrimination based on sexual orientation, or an individual's right to religious freedom and freedom of belief, which would trump over the other or prevail. And the court decided not to do that. What they did was they ruled that the commission's opinion in favor of the couple showed animosity and hostility towards the bakery owner, and that in and of itself violated his right to religious neutrality under the First Amendment. So there's not a whole lot of takeaway from this, but it is a decision is noteworthy. A lot of people think that the court missed an opportunity here to decide a bigger issue, as I said. But because it was decided on such narrow grounds, there's not a whole lot that we could take away from it. But it does maybe set the stage that in the next term, or the 1920 term, the court may actually rule on this issue. Okay, so what's coming up in the next term? The court has heard a couple of arguments on a couple of different issues already, and then they obviously have a long way to go with oral arguments throughout the rest of this year and into 2019. So they heard a case last week about whether or not the ADEA, the Age Discrimination in Employment Act, applies to small public employers. Many of you may know that under the ADEA, there's a employee threshold limit. So employers can only be subject to the Age Discrimination in Employment Act if they have 20 or more employees. And a small fire company in, I believe, California challenged whether or not the ADEA applied to this small fire company because they had less than 20 employees. But the individual argued that no, the statute should be read to include all public employers, not just those with over 20 employees. So we'll wait to get a decision on that. Also, there are two pretty big arbitration cases that are before the Supreme Court. Right now, there have been arguments on, the court will hear arguments on a case that addresses the issue of whether or not the Federal Arbitration Act, the FAA, allows a state interpretation of an arbitration agreement that would authorize class arbitration based on the language, a neutral language in an arbitration agreement, whether you will imply that a class can move forward in arbitration based on language that does not specifically allow for that. And in previous cases, the court has said that courts cannot presume consent from mere silence on the issue of class arbitration, or from the fact that the parties agreed to arbitrate. So the court will be looking at whether or not an agreement that does not specifically state that employees can bring a class arbitration, if that will allow individuals to do that, or if they have to individually arbitrate their claims. And then another case, it's called New Prime v. Oliveria, that will address the issues of whether or not the FAA, the Federal Arbitration Act, applies to independent contractor agreements. So that is in the context of trucking companies, but it may expand a little bit the FAA's scope and independent contractors. There's also a case that will be heard about whether or not a railroad company's payment to an employee for time lost from work would be considered compensation and subject to employment taxes. So that's something to think about if you pay people for time and they're not working for you. There's also a chance there are petitions to the court, but we haven't seen whether or not the court are going to take it up, about whether or not employment discrimination on the basis of sexual orientation is covered under Title VII. So we may see that in the upcoming term. There's also a pending case that may be decided by the court related to the Equal Pay Act. Under the Equal Pay Act, individuals have to be paid, comparable pay. You can't discriminate based on sex or gender in terms of compensation. And there is a case that may be decided to find out whether or not previous salaries can be used as a basis that is a factor other than sex to make a defense to an Equal Pay Act. So basically, can we look at previous salaries and see if they will enable us to pay men and women differently and not violate the Equal Pay Act? And finally, there are some union issues that may be decided. One is, does a union violate its duty of fair representation if it refuses to allow members to rescind their dues checkoff authorization when they don't fully comply with the union's requirements for rescission of dues checkoffs? So basically, can employees say, I don't want to pay union dues anymore, and have the union agree to that if they don't follow the rules that are set out in the collective bargaining agreement? And then there's another case, Creative Visions Resources, that deals with the issue of whether a successor employer in an asset purchase will be required to recognize and bargain with the unionized workforce of the predecessor employer. Okay, so we're going to shift gears from the Supreme Court, and we're going to move to the Me Too movement and its effect on the workplace. So a lot of people think that the Me Too movement just started a year ago and that we're only a year into the Me Too movement and it all started with Harvey Weinstein, but that's a misconception. The term Me Too was coined back in 2006 by a woman named Tarana Burke. She is an activist who started using the term Me Too to show solidarity with victims of sexual assault, sexual abuse, and sexual harassment. So a year ago, the actress Alyssa Milano took hold of this Me Too expression, put a hashtag on it, and it went viral on social media. And it became a viral campaign that was used to highlight the prevalence of sexual assault and sexual harassment, but specifically in the workplace. And this was in light of a lot of allegations that were coming out with people in the media and in the entertainment industry and in politics about allegations of sexual harassment and sexual misconduct. So I read a recent report just earlier this week that since the Me Too movement started about just over a year ago, at least 425 prominent men have been taken down essentially by the Me Too movement or have been somehow associated with allegations of sexual harassment, sexual misconduct. But that number is just the prominent men and women. And so we're here to talk about how this impacts the workforce that we all are in every day, because we're not all necessarily in the entertainment industry with big name employees. So it has impacted the everyday business world tremendously. And so why does the Me Too movement matter? It matters, one, because sexual harassment in the workplace is illegal. We all know that, and we all work to try to prevent that. But not only is it illegal, it has broader implications for the workplace. And it's imperative that employers take steps to address workplace harassment, because not only will you be in compliance with the law, but you will have better outcomes. You will have a more engaged workforce, happier employees, and a better organizational culture overall. So studies have been done that when employers took steps to address harassment, people reported a lot of benefits. So people who reported that their company took steps to address sexual harassment had better psychological health, or reported better psychological health. They reported better or greater job satisfaction, more motivation to work hard in the position, and a higher likelihood of recommending that company or organization to other people as a good place to work. So it obviously improves the overall work environment. It makes people want to stay. It makes people want to bring in other good talent, which all helps benefit the employer's bottom line. It's not just about dealing with litigation or sexual harassment legal issues. It can increase employee morale. And the EEOC has reported that more than $160 million have been paid out to victims of sexual harassment. And, even if it's not just a litigation, as I said, sexual harassment or harassment issues in general can affect the bottom line, because you may have increased turnover, lower productivity or morale, where people are not working really hard for the benefit of the company.
You have to pay lawyers.
And you have to pay lawyers, right? You have to pay people like me and Catherine, right? Those are expensive. So the EEOC in the past year, at first, they did not see an initial spike in charges related to sexual harassment when the Me Too movement first started, but over the past year, they've seen a 12% increase in the number of sexual harassment charges that have been filed. And also in 2018, the end of 2017 into 2018, the EEOC filed more sexual harassment litigations than they had in the previous year period. So it is playing out. The Me Too movement has made people more aware of their rights, and hopefully employers more aware of their responsibilities. So people may take steps to enforce their rights. I know from my own anecdotal personal experience, I have seen an uptick in harassment investigations that I've been asked to participate in the past year. I've done more harassment investigations than I have in any of my other years of practice in the past year. So some states are getting involved in changing legislation and requiring more from employers to combat the problem of sexual harassment and sexual assault in the workplace. And not surprisingly, California and New York are leading the way with these new statutes. The big takeaways, there's a number of points on this slide, but the big takeaways are that in California and New York, there are now limits on confidentiality requirements and non-disclosure agreements that can be included in any settlement of a sexual harassment claim. So it's going to be more difficult in those states to keep people from talking about their experiences and talking about the settlements that they've received. California gained attention a few weeks ago when it passed a law that now companies in California have to have at least one female on their board of directors. Talent agencies have to provide harassment prevention and other training for people in that industry. In New York, that's in California. In New York, there's a prohibition on mandating arbitration for sexual harassment claims. In light of all the arbitration cases that are before the Supreme Court, that may be challenged in the next year or so. And also, New York has implemented mandatory sexual harassment prevention policies and trainings, and the policy must be used in the employment handbook or whatever harassment policy the employer distributes. So if you have employees or you do business in New York or California, these are things to be aware of. And if you don't, and you're only here in Pennsylvania or maybe just Pennsylvania and New Jersey, it's something to look ahead to, because these are really the trailblazers in employment law generally. California, New York, sometimes New Jersey. So where they go, employment law may tend toward that direction. So it's things to be aware of from that vantage point. Okay, now I'm going to turn it over to Catherine.
Hello, everyone. Good afternoon. Just to follow up on what Terry was just saying, it's interesting to see what California and New York are doing, changing their laws with respect to sexual harassment, because they might be harbingers of what's to come here. Similar bills have been floating around the state house in Pennsylvania, but nothing's left committee. One bill that I think gets some press is potentially lengthening the statute of limitation to file sexual harassment claims under Pennsylvania state anti-discrimination law, the PHRA. It would lengthen the statute from 180 days to 2 years, which would make it more similar to the statute of limitations under New Jersey's anti-discrimination statute. So, practically, what steps should employers take in the Me Too era? A lot of these steps are steps that probably all of you have already taken in your workplaces and have implemented among your employees. I have, similar to what Terry was saying, really seen a greater awareness amongst not just folks who work in HR, but folks at every sort of level of management. When they get a sexual harassment complaint now, they know that it has to be elevated. They can't just sort of, turn a blind eye because they don't think that the person was really perhaps offended by conduct that might be harassment. They really have to look into it, and they're always when clients call me, they say, I think we need to put this person on suspension right away so we can investigate what's going on. There's an awareness that you must look into these issues when they're raised, and you must do it in a timely fashion. So a lot of these steps are ones that I think all of you are probably familiar with, but it's good to, always when you do perhaps an annual handbook review, look at your harassment policies, really make sure that your policies are understandable to your employees, that you have definitions as to what prohibited conduct actually looks like. Really think about your reporting procedures. Do they make sense? You want to make sure that employees have a variety of avenues that they can take to raise their complaints. I wouldn't recommend, saying that every manager is potentially someone that you can report to, because you really want to funnel these things through HR. So if people aren't generally directing their complaints to HR and they're going to other, management people who might not be as familiar with how you handle these complaints, sometimes the complaints don't get dealt with how they really should. On the other hand, you need to have more than one avenue. What if the complaint is about someone in HR? What if, the person someone is supposed to complain to is their direct manager, but the manager is the one, engaging in the offensive conduct? So you want to give people a couple, at least a couple ways that they can raise complaints in the workplace. Train all levels employees, including supervisors and senior executives. I actually personally think that training management is, perhaps even more important than training employees, because it's, really what is being asked of everyone in management is that you have to, be sort of an expert on the legalities of harassment and discrimination law, which is a lot to ask of people, and they need the support and the training to make sure that they understand, sort of the ins and outs of these issues and what they should do. And number one, that HR is there for them to support them and can help them when any of these issues come up. Communicate your policies with all employees. Consider establishing an open door complaint policy. So you want to make sure, which I'm sure probably all of you do, when you do, you revise your harassment policy or you pass it out to new employees in a handbook, everybody signs off on it, just so you can keep track that everyone knows what the policy is, and make it available to everyone. If you have an intranet site, it's a good place to put it. Follow up on all complaints. Again, just because someone thinks, is suggesting they weren't really offended, but this happened to them, you still have a duty to follow up on it, to look into it, sort of regardless of what you're hearing from the employee, which, sometimes it's hard for employees to understand why you have to do an investigation when they're telling you they're not really offended, but, that's the right thing to do. And, with this whole Me Too phenomenon, sometimes it turns out that someone who is engaging in, harassing conduct is not just limited to one employee. There's other employees out there who might have been impacted in a negative way. Keep investigations confidential. So that's important for many reasons, including that if you have this rumor mill situation where everyone's talking about, a complaint that an employee made and, people participate in an investigation, that creates issues. First of all, it's going to create a situation where not a lot of work is going to be getting done. People are going to be, gossiping instead. But it also can create a situation where people who participated in the investigation or made the complaint in the first place feel like they're being subjected to a hostile work environment because of all these, rumors and details about this investigation that are going around. So, keep investigations confidential to the extent you can. It gets a little bit tricky because employees who are not supervisors do have rights under the National Labor Relations Act that they can basically talk amongst themselves with respect to the terms and conditions of their work. So, you can't discipline employees for talking about perhaps harassment issues in their workplace. That can be seen as a violation of their rights under the NLRA, and the NLRA does apply to union and non-unionized workplaces, just as an aside there. Avoid a zero tolerance policy. I've seen that language in a lot of policies, and I don't think it's a good idea for a couple of reasons. First, if individuals believe that one instance could get someone fired, they're going to be less likely to report. They don't want to, sort of have that power over someone's ability to remain employed. The other thing is, it gets really tricky to follow your own policy if you say zero tolerance, because, I think we can all agree that, not all violations of harassment policies are necessarily of, equal severity. So, if someone makes sort of an ill-considered comment that, is perhaps a violation of your harassment policy, you might think that a more reasonable step to take would be, writing them up on a warning, a probation, counseling them, but not necessarily just immediately moving to terminate. So I recommend keeping that zero tolerance language out of your policies. Finally, it can make sense to hire third parties to conduct investigations of sexual misconduct or other alleged discrimination for that matter. The tough part about this is, that can get expensive, obviously, if you're going to hire someone from the outside, potentially a lawyer, potentially not. But this can be a good way to do it. When really serious allegations come up, and particularly if they implicate people in really high levels of management, say the CEO of the company, it's going to be, I think, difficult in some instances for people who potentially report to the CEO, for instance, human resources, to conduct that investigation. It just can put you in an awkward situation. So in some cases, it really does make sense to go out and hire a third party who can act like a little bit more of a neutral in investigating matters. So what's the bottom line of the Me Too movement? There's just a bigger awareness now that sexual harassment and assault are not only disrespectful and can be traumatizing, but that behavior creates a hostile and inefficient workplace that can be very costly to employers. This behavior can ruin careers, as we've seen time and time again in the news recently. Relationships lead to other unhealthy outcomes for those affected. So it's in everyone's best interest when any of this conduct sort of rises to the fore that employers nip it in the bud for the health of the organization and all of its employees. Employers should take all possible steps to ensure those who are experiencing harassment know they can report it, and those reports will be taken seriously. You always want to reassure complainants who come to you. You're going to take it seriously. You're going to look into things. It will be a confidential investigation, and they will absolutely not be retaliated against. And you should be using that same language whenever you're conducting an investigation and talking to witnesses as well. So switching gears again, now we will talk about medical marijuana in the workplace. So Pennsylvania's Medical Marijuana Act was passed a couple of years ago. The state enacted the Medical Marijuana Act on May 17, 2016. And now that you can actually obtain medical marijuana, it's becoming more and more of an issue, and it is a really tricky issue, and I'm just going to be upfront with you and tell you that the law is not crystal clear as to how you deal with all issues impacting medical marijuana. But we are going to work through some of those issues. We're going to give you some guidance here, and I'm going to let you know that, again, some of the answers here are still a little bit unclear. So Pennsylvania is not alone. It joined 30 other states in legalizing medical marijuana. In Pennsylvania, individuals with certain health conditions are eligible to use medical marijuana. Those health conditions include HIV/AIDS, autism, cancer, PTSD. There's other specific conditions that are enumerated in the law. Just to be clear, the law does not permit individuals to smoke marijuana. That is against the law in all circumstances. However, they can use marijuana in pill form, oils, topical gels, creams, and ointments. A certification from a healthcare provider and an ID card from the Pennsylvania Department of Health is also required to obtain and use medical marijuana. And just to be clear, marijuana is still illegal under federal law. It's classified as a Schedule I drug under the Federal Controlled Substances Act. And because marijuana is illegal under federal law, that means that you don't have to accommodate the use of medical marijuana under the Federal Americans with Disabilities Act. Additionally, there are certain federally mandated drug-free workplace programs. Workplaces subject to U.S. Department of Transportation regulations require employers to report positive marijuana tests. So because there's it's just a really big tension between state law here and federal law, and that causes, it makes things complicated, let's just say, for employers. Okay, so one of the big takeaways here when we're talking about medical marijuana is that Pennsylvania's law prohibits discrimination for those who are legally certified to use medical marijuana. So you can't discriminate against someone based on their protected status here. The protected status is that they're legally allowed to use medical marijuana. That is clear. Under the statute, like I said, there's some things that are a little bit murky still. There's no explicit cause of action under the statute. There are penalties, and there is individual liability under it. So there's this anti-discrimination provision under the state medical marijuana law, but again, marijuana is a Schedule I drug under federal law. You know, how do you resolve that tension? There was a recent federal case in Connecticut interpreting Connecticut's medical marijuana law that provides some guidance for Pennsylvania employers. So let's just really briefly talk about that decision. So it came out just this past September. The federal district court in Connecticut ruled on an anti-discrimination provision in Connecticut's medical marijuana law that's similar to Pennsylvania's anti-discrimination provision. The court there found that the provision contained an implied right of action. They also held that this employer, who had a zero tolerance pre-employment drug testing policy, had violated the anti-discrimination provision in Connecticut's medical marijuana law. So the takeaway here for Pennsylvania employers, just sort of, analogizing the Connecticut law to the Pennsylvania law, is that the blanket refusal to hire someone because they failed a drug test, but is a certified medical marijuana user under Pennsylvania law, could subject the employer to liability. So if you have a policy where you test all new hires for marijuana and someone is positive, you can't just say, sorry, we're not going to work with you. It's more complicated now. So what's this all mean? Can employees now use medical marijuana in the workplace? No. An employer, under the statute, it's clear an employer is not required to make an accommodation for the use of medical marijuana on the property or premises of the workplace. So don't worry, you don't need to provide your employees with a location to use medical marijuana. But what about accommodating the employee to leave the property and use medical marijuana? That's a bit unclear right now. What about disciplining medical marijuana use? You know, obviously you can't have employees who have used so much of a substance that they are impaired and cannot perform their job. Under the Pennsylvania law, an employer can discipline an employee for being, quote, under the influence of medical marijuana in the workplace. Now, the tricky thing here is that under the influence is not well defined in the law. The law also provides that employees can be disciplined for working while under the influence when the employee's conduct falls below the standard of care normally accepted for that position. It is, because it is tricky to determine what under the influence means, and we'll discuss that a little bit more in depth in just a second. I'm just going to say the safest thing to do here is if someone is impaired and unable to do their job, the safest thing to do is just to focus on the conduct. Don't try and figure out or speculate, oh, I think this person, you know, is a medical marijuana user, so I think they must be high, and, you know, that's the problem. Just look at the conduct. If you can discipline them for the conduct because it's falling below your standards, you can't go wrong. That's absolutely the safest way to go. But again, there's these unanswered questions. If you do want to discipline because they're, quote, under the influence, how is that defined? The statute is not really clear on that issue. And how do you prove it? It's tough because marijuana remains in people's systems for a long time. So, you know, if they're a medical marijuana user, you know, obviously they've used medical marijuana recently if they're, you know, actively taking advantage of the fact that they can use medical marijuana legally. But it doesn't necessarily mean that they are, you know, currently impaired. So, you know, how does an employer prove that employee is under the influence? Well, you could do a drug test, but like we just talked about, there's some issues with that. And you can make observations. Are they acting impaired? Just sort of using common sense, you know. But again, the safest thing to do here is to focus on the conduct, to focus on the performance issue. There is a permissible blood content that's listed in connection with some of the provisions of Pennsylvania's law, but not all of them. So again, the statute here does conflict with federal law, and the Pennsylvania statute actually says nothing in the act shall require the employer to commit any act that would put the employer or any person acting on the employer's behalf in violation of federal law. And you might say, but this law in its entirety seems to contradict federal law, and I would agree with you. So again, this is all sort of, it's unclear how this is going to play out, but, you know, sort of best practices here are, again, don't discriminate based on someone's status as a medical marijuana user. And, you know, if there are issues with someone seeming like they are under the influence, despite the fact that they, you know, have a card and can legally use medical marijuana, you know, that's something that you're going to have to really analyze each of those situations closely and perhaps consult with counsel. So we're running short on time, so I'm going to try and go really quickly here. There is a carve out under the Pennsylvania statute. Anyone under the influence of medical marijuana can basically not perform certain safety sensitive positions. But again, under the influence, it's a pretty unclear under the statute. And it's unclear how this really deviates from sort of the general premise of the law, which is that employers in general don't have to permit their employees to be under the influence of medical marijuana while at work. New Jersey also has a medical marijuana law that you might be familiar with. It is a little bit different in that employers are pretty clearly carved out. So in New Jersey, if your employee does test positive for marijuana, you can act a little bit more swiftly and take adverse action against them. So what can employers do? If your business is subject to federal laws mandating a marijuana-free workplace, continue to abide by those requirements. I would recommend not asking applicants if they're certified to use medical marijuana. That can open sort of just a Pandora's box. You know, if you don't know that they use medical marijuana, they can't, say that you're discriminating against them because of their status. Ensure that safety-sensitive positions, including any tasks that may be life-threatening, are fully explained to employees. You should absolutely have job descriptions. And think about this issue when you're creating your job descriptions or looking over them, and perhaps incorporate some of the verbiage in the statute into your safety-sensitive job description. If an employee tests positive for marijuana, whoever is conducting that testing should determine if the employee has a state-issued medical marijuana identification card. When you do your sort of anti-discrimination, anti-harassment training for supervisors, a new topic to bring up now is medical marijuana. You might want to modify your anti-discrimination policy to also include medical marijuana status. And if you think there's an issue, document it, just like everything else. And again, rely less on sort of speculating based on your knowledge of the person's use of medical marijuana and focus on the conduct. And again, as you do with all employee medical information, keep it confidential. Don't let it become, fodder for the rumor mill that, such and such, has a card that enables them to legally use marijuana. So this concludes the presentation portion of our webinar. And I think we're going to the questions now.
Thank you. We're now going to open it up for questions. If you have a question for our speaker, please type it into the question box at this time. We do have a couple questions already, so I'm going to start with those. Are you able to recap those upcoming union issues at the end or send out additional notes? It went fairly fast.
Sure. The upcoming union cases that are before the Supreme Court?
Yeah, it says upcoming union issues. So yeah, probably the cases.
Okay. So the one case was whether or not a company that purchases another company that has a unionized workforce already in place in an asset purchase sale is required to bargain with the union that's in place at the predecessor employer. So do you have to, if you're in an asset, buying the assets of a company, are you obligated to bargain with the union? So that is one that's coming up and, maybe heard this term. And another one is whether or not a union can refuse to allow union members to say that they no longer want to pay dues. Like if union members don't want to rescind their dues check off and say, I don't want to pay any dues anymore, can the union refuse to allow them to do that if the individual does not meet certain requirements that are in the union contract. So essentially, this case was around someone said that they didn't want to pay union dues anymore, but they didn't send it via certified mail or within a certain time frame of the collective bargaining agreement going into effect. And the union said, well, too bad, you have to pay your dues now because you didn't do it the way that we require by the contract. And the individuals say, well, that's not fair, not right, and they've brought this claim saying that the union can't do that. It's a violation of their duty of fair representation to refuse them to allow to back out of paying union dues for union membership. So those are the two cases that may be coming down the pike in the future in this term.
Great, thank you. And this is in reference to the EEOC report on the Me Too movement. Over what time period does the $160 million include?
I don't think it's just in the past year. I think it's over an extended period of time. That's the EEOC's calculation of the EEOC's verdicts.
Okay. Next, how do you deal with someone being high at work?
I mean, if they're high at work, if they're under the influence, then first of all, I'd say, can we sort of take the easy way out on this and focus on the conduct? Are they like nodding off at their desk? Are they not doing their work? Because if you can purely focus on the conduct and discipline on that, then there's no sort of complicated legal issues that you have to deal with. You should have a drug testing policy. If you have a drug testing policy, then you can, if you reasonably believe the person is high, you can drug test them. You can also make some common sense deductions as to whether or not the person seems like they're impaired and high just based on your own visuals. And I would get another, manager or two to kind of, look at the employee and, see if they agree with you, because that's going to sort of make your case stronger that the person was indeed, high at work and should be subject to discipline and perhaps termination. If someone is, coming out of their car in a puff of smoke, I can tell you that that's a pretty clear case. Because first of all, you can't smoke marijuana under this new law, even if you're, someone with a card that says that you can use medical marijuana, and you can take more forthright action in that situation.
And also, I think it's important to document observations that you see. I've seen people institute a checkoff before you send someone for a reasonable suspicion that describes their demeanor. It describes their physical appearance and any smells that may be emanating from the person, because the smell of marijuana, if it's smoked, does stick with people for a period of time. So having a form that before you send someone for a reasonable suspicion test, or even if you don't do drug testing, having a form that describes the observations that you've seen can help back up any decision that you make.
That's great advice. And practically the way I've seen a lot of these situations go down, and not limited to marijuana, but just, alcohol or, other illegal drugs, is you notice this person seems impaired at lunch this day, then they seem impaired at lunch, 2 weeks later. And it's just something that if you document it along the way, it's going to just sort of make your, so to speak, case stronger that this employee is using and is impaired at work.
Okay. The next question is asking if the presentation is going to be made available to all attendees. Yes, we will be sending a copy in PDF format to everyone in the follow-up email. Next, how are medical marijuana laws applied for an employee who may have a medical marijuana card in the state where they live but work in another state? What jurisdiction takes priority?
So if the state where they work does not have a statute related to medical marijuana, I guess that's the question, because, in Pennsylvania and New Jersey, there are statutes. I don't believe that there's one in Delaware. I'm thinking of the local states. It may be that I don't think the federal statute will be read to have to accommodate drug use, because the federal government is taking a position where these are still controlled, prohibited substances. But it may be that a state disability statute might require some form of accommodation. I think that if that issue does come up, I think that's one to reach out to council directly, because honestly, I think that would require us to do a bit more research on how that's played out. But I wouldn't rely on the fact that the ADA would not require an accommodation, but a state statute, even if there's no medical marijuana law in place, a state statute may require an accommodation under those circumstances for the underlying condition that is necessitating the use of medical marijuana.
That's a tricky question. It always is difficult when you sort of have two states' laws that might conflict with one another. So that's a great question, but it's one, unfortunately, the answer is it really depends, and we'd have to know sort of all the particulars to give a really hard and fast answer.
Yeah.
Okay, 2 more questions. In Pennsylvania, as it relates to medical marijuana in Pennsylvania, we have a pre-employment test. How should a positive marijuana test be handled?
Okay, so this is a Pennsylvania employer. They do drug tests for all their new employees. So if you get a positive, the person who's handling the drug test for you, just like they always, they'll ask about like medications you're on and stuff. So after the positive result comes back, the person who tested positive should be asked, are you legally allowed to use medical marijuana? And you should ask to see their certification and their identification card. And then, where you go from there depends on the job, really. And, is this basically, is this a safety-sensitive position? If there's concerns about that, you can talk to the employee. Is there some other accommodation maybe to help you besides you using medical marijuana? You can hopefully give a job description. I really think job descriptions are key for so many reasons, and this is definitely one of them. If you had concerns, you could give the job description to the employee to take back to their doctor and get their doctor to sign off and say, this employee can perform the essential functions of the job. So those are my thoughts on that question.
Okay. How do you handle an employee who is ill and needs to take medical marijuana during the workday, especially if it impairs how they effectively do their job?
Okay, so what I understand from that question is basically like you sort of want them to be able to use the medical marijuana so that they can perform at work. So this is an issue where it's like a little bit murky. Like, do you have to accommodate that? Do you have to be able to, first of all, we know explicitly from the statute you don't have to permit the employee to use the drugs on your premises. I guess you could if you wanted to. I don't know that I would set that precedent. That's definitely something to think long and hard about. But it's gray to me whether or not you would say, say the person, I don't practically know sort of how often someone would need to take medication like this, but say they need to take it every 3 hours. So do you accommodate them? Do you let them leave the premises and take the pill and then come back, every 3 hours. Well, I think the way you would look at that is just how you do any other request for an accommodation. Is this going to be an undue hardship? Is this too disruptive? But I generally counsel employers, frankly, to accommodate where they can. So, particularly here where it sounds like, you want the employee to be able to use medical marijuana so that they can, perform their job at a high level. I think it makes sense to accommodate them.
All right, let me see if I think that is all the questions. So I'm going to turn it back over to Dana to close out our webinar.
Thank you again to today's speakers for taking the time to share their knowledge with us. Thank you to each of you for joining us for today's webinar. As a reminder, please look for the follow-up email with the link to the survey. Be sure to complete the survey in order to receive HRCI and SHRM credits, and visit www.phillyshrm.org to register for other upcoming events, including our November 8th webinar on leveraging strategic corporate social responsibility and our December 6th in-person event on reimagining HR in the age of artificial intelligence. Please don't forget to register by January 31st for the biggest savings on our annual symposium in March 2019. On behalf of Philly SHRM, thanks again and enjoy your afternoon.